Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and good day. I am Amirah Syuhadah binti Azman and I am presenting case study of Sherina Nur Elina binti Abdullah against Kent Well Edar Sendirian Berhad. So in this case study, alright, so the we will in this presentation, I will summarize the facts, issues, and judgment of the case, and as well as the applicable laws and similar law cases or law cases that are referred pertaining to this case study. And the facts of the case is the plaintiff, which uh, which is a former beauty pageant queen, when now is a convert Muslim, has sued the defendant for publishing without her consent of her photograph and image of during her um, being a contestant of beauty pageant, and the fact that her image appearing on packaging of the defendant's product, particularly the rice packaging, and which has been sold in retail shops, grocery stores, supermarkets, and hypermarkets in Kota Kinabalu, Sarawak. And the plaintiff also discovered not only the photograph and image used in the defendant's packaging, but as well as on large advertisement board, which is also located in Kota Kinabalu, Sabah. I'm sorry. Um, so the plaintiff sued for copyright infringement and invasion of privacy. The issues here from the court is to determine the question whether the plaintiff has the legal standing or locus standi to bring and maintain this action, and upon this question being determined in the negative for a consequential order, that this action be dismissed with cause. And the High Court, the decision from the judgment from the High Court was, the plaintiff's action for copyright infringement failed because she is not the owner of the copyright, and the photographs of her were created by organizers of events where she attended, or by the photographs who took them. Therefore, she has no local standi to initiate the action. And although the plaintiff is at liberty to sue the defendant for invasion of her privacy, in an instant case, the defendant did not intrude onto private property and took photographs of the plaintiff without her consent. Um, and also, the photograph that were taken, it was many years ago, and it was taken by someone else at beauty pageants, where she participated willingly as a contestant and also in public. Therefore, it was not in a private affair or on a private property. And also, the photographs that are displayed were not offensive. So the plaintiff did not complain then, and then she had been that the fact that now she had been felt humiliated or ridiculed or scandalized by the photograph or image. And from her affidavits, these pageants were reported and the photographs were published in local newspapers. The particular photograph or image which the plaintiff complained was an invasion of her privacy, also published in the book by Sabah Tourism Board in 1992. It was reproduced by the defendant on his products. The photographs are in the public domain, and it was cannot amount to the invasion of privacy. So the final judgment is the High Court decided to dismiss the plaintiff's claims with cause. Alright, so the next one is the applicable laws that has been referred in this case, which is as mentioned as in section 7, clause 1, clause 1, section C of the Copyright Act 1987, providing the artistic work shall be eligible for copyright. Artistic work is defined in the Section 3 of the Act to mean graphic work, photograph, sculpture, or collage, irrespective of artistic quality. So therefore, a photograph or photographic image is eligible for copyright. Section 10, Clause 1 provides that copyright shall subsist in every work eligible for copyright in which the author, or in the case of joint authorship, or any author is, at the time of the work is made, is a qualified person. And a qualified person is defined in Section 3 of the Act in relation to individual uh, or citizens of a permanent resident in Malaysia. And B, a relation to body corporate means a body corporate established in Malaysia and constituted or vested in legal personality under the laws of Malaysia. And under Section 3 of the Act, author is defined as in relation to photograph, meaning the person whom made arrangement of the photographs were undertaken. So this shows that the defendant uh, had the right to take pictures or to take the photographs without the consent of the plaintiff, as the pictures are already in the public domain. And one of the cases that is referred, one of similar cases that is referred is the Maslinda case, where she was caught in urinating in a vehicle while someone recorded her videos of her actions. So which is also included in tort of privacy of tort. And that is all from me. Thank you. Assalamualaikum.